Good afternoon, ladies and gentlemen. It's my great honor to have all of you come to this fascinating university and this lovely room today for discussing the most important topic, I think, in the post-financial crisis, which is namely the involute and complex login story between the intellectual property and securitization. This topic is it's not only related to financing part, it also has a very close relationship with the legal respect. So let's start. But today I will mainly focus on three parts. The first one, I would like to give a brief introduction about the history of intellectual property and securitization. And the second, I would like to shortly talk about the structure of the intellectual property securitization. And the third, I would like to slightly analyze the impact the financial crisis have on the intellectual property securitization. Before I started, I really would like to give you guys a small picture of what is how it feels the financial crisis in 2008. So it was the 2008, was an unforgettable year, and the history has seen the collapse of the great Lehman Brothers company, and also the bursting of the financial bubble, and the panics in the banking system, and also the stock market crash. And also the whole international financial system was going to the age of the abyss. So this is how it feels in 2008. Therefore, 2008 becomes the watershed of the financing market, financial market, and also the legal world. Before we're jumping into the bulk, I would like to ask your permission to briefly introduce the history of the intellectual property and the securitization. Because based on this background, what I talked is the watershed, we need to think about how this financing crisis influenced the intellectual property securitization. First, intellectual property. So intellectual property is generally characterized as intangible property, which is the product of the original thought. And intellectual property right surrounded by the control of the physical manifestation or expression of the ideas. And also the intellectual property law protects the creator's interest in the rights by assigning or enforcing the control and produce the instantiation of the ideas. So those are what we understand about the intellectual property and the intellectual property right and the intellectual property law. But as we know, the history of the intellectual property protection could be traced back to the ancient Greece and Rome a long time ago. And one of the first known reference to the intellectual property protection was dated from the 500 BC, which was in the Greek time. When the chefs of the great colony of Sybaris were granted a 1-year monopolize for producing a particular culinary delight. So this is actually the first case of intellectual property right protection. And also, based on the research of the Stanford University scholars, there are some other notable references of the protection to the intellectual property right in the ancient time. One of the most famous one was the guy who called the Marcus Marcus Virtual Views Polio. Excuse me for the name, it's really hard to pronounce. So, who was an architecture and a writer, and he has revealed the intellectual property theft in a literary context held in Alexandria as a judge. So this was that case in that time. But basically, those examples are treated to be atypical. So as far as we know, there were no institutions and conventions of intellectual property protection in the ancient Greece and Rome. Until the birth of the Florentine Republic, there was a patent statute called 1421. The modern intellectual property protection may gradually build from that time. But unfortunately, for that statute, it only issued one patent during its valid life. But 150 years later, there was a statute that was monopolized from England, and this is the start of the modern intellectual protection. And after there were various conventions were forged, and the whole modern system gradually built during that time. So, seeing through the history of the protection to the intellectual property, especially at the time of the Elizabeth I and the James I, which is the dark time of the abusing the intellectual property right, we could easily figure out one outstanding characters of the intellectual property right, which is the great monetary value granted by the monopolist. So after that, I would like to introduce the history of securitization. First, if you guys Google the securitization on internet, you could find at least 5 definitions. But here, I would just like to give a simple description about what is the securitization. So securitization basically is creation and insurance and the issuance of the debt securities or the bonds whose principles, whose payment of the principals and the interest were basically generated from the independent asset pool. So, and the historical rules of the securitizations could be found in the Great Depressions in the 1930s in United States. Well, during that time, because the housing credit market and the other markets are collapsed together, so the Congress reacted by passing one National Housing Act of the 1934, intended passed to create the secondary mortgage market. And because those legal fundamentals, the flourishing of the securitization gradually appeared. After that time, especially after the 1970s, a lot of various new types of the securitizations coming up, like the auto loan securitization, or the student loan securitization, and also the credit receivables. All these kind of assets could be securitized later on. Through the thriving of the securitization, we could easily say one of the outstanding traits of the securitization is the securitization has the ability to restructure the various intangibles and maximize the hidden values of all those debts. So I hope everyone is still with me because it's a little bit long about the history, boring stuff, but it's very necessary. After this brief introduction about the intellectual property and the securitization, Now I would like to invite you guys to jump into the slum with me to study the complex knowing structure of the IP securitization. But before that, I would like to give, I didn't plan to do that, but I feel like I really need to do it because I really hope you guys will understand later about the structure of the financial market. So basically, you know, the financial market is a market with a lot of securities flowing inside. So all those securities, we could say, generally in nowadays, it refers to the four main types. The first one is we call the debts. The second one we call equities, and the third one we call option, and the fourth one we call its future. So for the debts, maybe you guys have already know it included the bonds and the junior debts, the senior debts, and blah blah blah. And then for equities, you have the common share and the preferred share. And for options, you could have put option and call option. And then for futures, you could have long futures or short futures. So those are the basic main types of the securities running in the modern financing market. And for how the securities works, we have institutes like the trading market, like the Nasdaq or the New York markets, or in Canada, TSX. So this kind of thing. And for the structures, how the companies issue these securities, they could take the traditional structures, or they could take the new structures like the securitization. For securitizations, there are mainly either in Europe or in North America, we have at least 3 or 4 common paths. First one, we may call it the residential or mortgage backed securitization, and the other one maybe is the commercial mortgage backed securitization, and we also have the collateralized mortgage securitization, and then besides those, we have others. So what we're talking about, the intellectual property securitization, it belongs to the others. So you could say it's only take a very small piece of the big cake. That's why we say it's a new trend. So this is basically the structure of the financing market works today. Now I'm going to go to the introduction about the IP securitization. So in 1997, as we all know, David Bowie, who was a very famous musician, has issued the first music royalty-backed bonds, as we call the David Bowie bonds. So intellectual property securitization has become the new trend since then. As we noticed in the relationship of this transaction, one of the parties, which is the intellectual property, is with a great economic value, but it is very unstable and unsustainable. And the other part, the securitization, it is equipped by the energetic money-generating motor, but that structure is very sinuous. So perhaps you may want to know how these two unstable and complex things could work together in the post-financial crisis. So let's say the first, the structure of the transaction first. So the structure. Maybe this one is better. So for the structure, as we all know, as a common securitization, I have some players in this game. So there are main 3 players. We call it the borrower or the originator, and that's PV, which is a special purpose vehicle, and it's the investors, and some other small players. So first, for the borrowers, we call it originators. So these borrowers, you need to know first, they are companies or whatever, like parties, institutes, who has the needs to have money. This is the borrower. But for borrowers, it could be a big companies as IBM or Dell, these companies with a good credit rate. Or it could be just startups companies, like small companies without the great credit rate. But the common thing for them is they have the needs of money, of having money. So those are the borrowers, and then they want to borrow money. So how they could have the money? What's the important thing is they have to own a great intensive intellectual property which could generate a stable cash flow. So that's the key point for the borrowers to be an eligible borrower. And then it needs to go to the special purpose vehicle. For the special purpose vehicle, it is created by the originators or the borrowers, which is independent from them. Why it's very important, we'll talk about later. So for this SPV, it must not have any financial liabilities other than the abilities to holding the assets pool. So it cannot have stops, things like this. If you want to ask how it would work, well, because the SPVs could be a company or the trust or a partnership as well. And also it could have another outside companies to manage the business of itself. And then we have investors, so it's the money, the source of the money. So people want to invest it into the bonds or debt securities issued by the asset pools. As we mentioned, there are other small players. So these players could be like the bank, which is the financial institute to help the SPV to issue the bonds, because you need to have the bonds to attract the investors. And then we may need the guarantees or the credit guarantees to help the investor to be secure and to buy this bonds. So we may have the insurance company or some other credit enhancement tools. So basically, those are the main actors in this game. And then after, I would like to talk about the relationship between all those actors and the money, how the money and the assets or cash flows could transfer from one to the other. Basically, we'll just talk this main three. So for the relationship, it's also very complicated because first, when the borrower wants to transfer the money or the assets to the not the money, the assets to the SPV, it has to be a true sale. So what does it mean for a true sale? True sale means like after the sale, the assets in the SPV will be isolated from the assets of the borrowers. So it means once the borrowers go to bankruptcy, it will not influence to the assets of the SPVs. This is very necessary because it will ensure the investor they will not have a very high risk related to the company's default in the management and performance. Based on some scholars' research, they divided the transaction into two general types. What we call is the direct transaction and indirect transaction. Based on what? Based on the type of the assets they transfer. If the borrower only sells the IP rights itself, it will forge the direct transaction because the risk of the investors will fully concentrated on the assets itself. But if the borrowers only sell the agreements which has been signed with the third party to permit them using the intellectual property and having some license fees back, which generated the stable cash flow. This transaction would be defined as an indirect transaction. And so what's the point to define this tool? It's only to say the difference of the risk. But here you need to understand in the direct transaction, even if we have the investors will be exposed to another risk, we call it the licenses credit risk. But it doesn't mean in this transaction it's more risky than the first one, because usually in the license agreement you have the fixed royalties. So it means this fixed payback will reduce the risk. And even if one of the licenses has been default, the patent owner could revoke the patent right and to issue it to other people to keep the whole assets pool diverse. So it will help totally reduce the risk. So those are the two different transactions of this structure. Basically, this structure has a lot of advantages and a lot of risk, as we can see, but we cannot say this structure is unreflexible. Unreflexible. Because why? Because as we say, this structure only takes a small piece of the cake. So and also because now, especially after the financial crisis, it's becomes more impossible to become a growing and bigger. But why? We will talk about it now about the influence of the financing crisis to this structure. As we can see, after the 2008 financial crisis, the market, the confidence of the market has been deflated. So basically means the investor doesn't really trust the securitization. So they don't want to invest their money into something more risky and cannot predict the future payback. So what we can do, so most of the countries, especially in Europe and in North America and US, let's say, they try to recover the home market and the confidence. So they started to establish some legal reforms. But based on some research, this legal reform in short term may actually temper or delay the investors from returning back to the market. Because for example, one of the reform was called Basel III. In this reform, they have one term says it excludes the securitization as eligible securities. So basically, it means like no one would the debt securities generated from the securitization cannot be eligible securities issued in the market. So basically, it killed the way the asset-backed securitization growing. So this is a really bad impact. But from other scholars, they think in the medium term, this new laws would actually bolster the investors' confidence and help them to help the market to be recovery and also the securitization find a new way to growing in the future. So basically, this all the influence by the financial crisis on the market and how the government reacted to it by issuing some establishing some new reforms or whatever. But at the very end of this presentation, I would like to ask a question because we really need to think about it. No matter whether there are new laws coming up or whether in the past past this long history, why on earth after 15 years the birth of the intellectual property securitization, there are still only quite a few transactions have been taken in the market for real, and why the legislators never really mean to establish any laws to regulate this new trend. So this is the thing we need to think about. Maybe it's because the complexity, the complex nature will make this new type of the transaction queued by itself because it's too complicated and no one wants to take that. Or maybe because we need to improve or change our associated systems like the banking system or financial system or other legal system to adapt to the new trend in the future. So this is the questions we really need to think about because this new way of financing is really important for the small companies. And in my opinion, maybe in the future, the small companies will become a very active factors or players in the future economy. So, well, it doesn't matter whether we will change the intellectual property law or not, but still, if it will become small companies will become a active player, we may think about how it could benefit them to have money in the future in this way, especially for the companies own a lot of intellectual property rights. So basically, this is all I want to talk today, and thank you for your time and patience, and I really hope I didn't waste all your time. Otherwise, I really commit a very serious crime because wasting other people's time is equal to killing people. So thank you again, and if you guys have questions, you could ask, and I will answer here.